Essentially, the best way I can put it is that the public does have a very broad right to know, but it's not unlimited. And Greg told you about some of the exceptions. And in the criminal realm, in criminal investigations, especially investigations that are pre-indictment, meaning before we've indicted someone, the right to know, the public's right to know, is very limited. And essentially the reason is this, that in the United States we've decided that it's important to try cases in a courtroom and not in the media, not out in the public. That's something that, depending on your perspective, you might not always agree with. Certainly, often when we talk to family members of victims, they're frustrated with the process. They feel like it's too protective of the defendant. But certainly, if you ever have a friend or family member who's been in trouble with the law, I think you'd agree that you and they appreciate all the rights that are afforded criminal defendants. And one of the important rights is the fact that, again, we try our cases in the courtroom and not in the media. The other reason that the right to know law is limited when it comes to law enforcement activities at certain stages is that the law gives us, prosecutors and police, a chance to investigate and solve the case. If we tell our suspects out there what we're doing and what evidence we have, it would make it very difficult or impossible for us to solve cases. And so we're allowed a window. It's typically a pretty short window, but we're allowed a window where we're allowed to operate, I won't say necessarily in secret, but where we don't have to disclose publicly what we're doing. Not just to the public, but to suspects, potential defendants in a case, and potential witnesses. It's hard to explain all the time why, but I will tell you that secrecy is one of the most important weapons that we have in law enforcement. Our ability to do things and not tell the people that we're targeting what we're doing is often the difference between solving a case and not solving a case. And the things that we do aren't necessarily secret. It may be specifically how we do them, when we do them, and exactly where we're doing them. So we need the ability to be able to do those things in order to solve our cases. Pretty much the rule in New Hampshire is that it's determined on a case-by-case basis. Meaning, depending on a particular case, we may be able to keep things secret for a very short period of time or for a very long period of time. And Greg had mentioned the Bowman search warrant case, and I'll talk about that case for a minute because that's actually good guideposts for what we're allowed to do and what we're not allowed to do. That was a July 16th, 2001 case that went up to the New Hampshire Supreme Court. What happened is this. Our office was investigating the disappearance of a mother and a daughter, the Sinclairs, over in the western part of the state. They went missing, and we began a criminal investigation in conjunction with the state police. Part of that investigation, like many of our investigations, we went and obtained search warrants in the case. And those search warrants were obtained from a local district court, and those search warrants were sealed. Greg talked to you a little bit about that. In order to have search warrants sealed, we have to file a motion with the court and justify why we want those search warrants sealed. And we did that in that case. A local newspaper found out that we had done search warrants. They didn't know what we'd done. And they asked the court to unseal those search warrants. And the court held a hearing, and they ended up ordering us to turn over, they ended up declaring that those search warrants would be unsealed. We asked the court to stay or to temporarily halt this decision, and then appealed it up to the New Hampshire Supreme Court. And on July 16th of 2001, the New Hampshire Supreme Court came out with this ruling. Essentially what that ruling says is this. The court said that the district court was wrong, and that generally speaking, when you have an ongoing criminal investigation, and the case is in the pre-indictment stage, meaning no one's case has gone before the grand jury to be formally charged with a felony, that generally speaking, that is a justification to keep the search warrants and the investigation secret. It's kind of a bright line rule. In other words, it pretty much told the media, it told the public, and it told the police and prosecutors generally what the rules were, which is it gives us, the police and prosecutors, a limited period of time, generally, to investigate a case. Why do I say limited generally? Because the Bowman case is actually still going on. That was back in early 2001. We haven't been able to solve that case, but everything is still under seal. And the reason is it's still an ongoing investigation. I think that we have a pretty good understanding, though, of the balancing. Obviously, we need some level of secrecy to solve cases. That's important. I mean, that's what the public wants us to do. At the same time, there's a tension, as Greg talked about, with the public's right to know. The public has a right to know, and they should know what we're doing. They pay our salaries. So often we have to do this balancing. We do it between, is it okay to release that? What should we release? What's okay to tell the public? When can we tell the public? And we try and do that balancing. And we certainly are very cautious in that and we try to be careful about what we say. But we understand that there's a benefit to that. It's important that people know what we do. What we do is an important job, and we want the public to know it. Also, the media can be helpful in some of our cases. There are times when we want to specifically release certain information to the media. We may have a murderer on the run, or a suspect who's missing, or maybe there's evidence that we're looking for. We want to enlist the help of the media. So there are certainly times when we'll decide to put out more information to try and enlist the help of the public and the media. But there is a tension, and it's constant and ongoing on all of our cases, and we constantly have a discussion about what can we release, what should we release, and what's the timing of that. And that happens in every case.